Hey everyone, Lee Pacchia here from Mimesis Law. We're talking about voting rights litigation today. I'm happy to say we have Professor Erika Wood from New York Law School joining us. Welcome, good to see you.
Hi, thanks for having me.
Of course. So we've had this flurry of activity in voting rights litigation in the past couple months. Can you walk us through what you see as some of the major developments?
Sure. So the most recent one was in Texas, which had one of the most restrictive voter ID laws in the country. Went into effect immediately after the Shelby County decision last year. There was a big trial this summer in Texas. Lots of witnesses, lots of evidence considered, and the district court just a couple weeks ago came out with a really monumental opinion finding that the Texas voter ID law not only discriminated against minorities in the way that it was being implemented, but in fact had been passed with discriminatory intent. The court found in that case that there were 600,000 registered voters in Texas who did not have the required ID that they would need in order to be able to vote just next month. So that case was appealed to the Fifth Circuit Court of Appeals, which actually stayed the district court's opinion and reimposed the voter ID law in Texas, saying it was just too soon to the election to be changing those laws. And just yesterday morning, voting rights advocates appealed the Fifth Circuit's opinion directly to the Supreme Court. So we're waiting for the Supreme Court, could be any minute now, to rule on what actually the voting law will be in Texas leading up to the midterm election.
Why is it so busy and why now?
So I think it really comes from this Supreme Court opinion in 2013, Shelby County versus Holder, which was the most critical voting rights opinion we've seen in the last 50 years come out of the Supreme Court. In that case, the Supreme Court struck down what was Section 4 of the Voting Rights Act. Folks may be aware that under the Voting Rights Act, states that had previously discriminated against minority voters through post-Reconstruction, Jim Crow years, through the Civil Rights era, with things like poll taxes and grandfather clauses and literacy tests, that there were certain states and regions in the country that were covered by the Voting Rights Act, meaning they had to seek permission from the federal government before they could change any of their voting laws. And in the Shelby County opinion last year, the Supreme Court found that section of the Voting Rights Act to be unconstitutional, essentially saying that although Congress had reauthorized the Voting Rights Act with overwhelming bipartisan majorities in, I think, 5 different times as recently as 2006, finding that, overturning basically that congressional action and finding that this section of the Voting Rights Act was unconstitutional and placed too much of a burden on the states. As a result of that, literally 24 hours after that opinion was issued by the Supreme Court, Texas reinstituted its voter ID law. Within a week of that, North Carolina imposed one of the most restrictive voter ID laws in the country. Both of those were states that had previously been covered by the Voting Rights Act, and the Department of Justice had previously prohibited them from passing those laws.
It's hard to generalize in situations like this because it's so ridiculously complicated, but for advocates of voting rights, have the last 2 months portended an improvement in the situation? Is it not? Is it the opposite? Are things going sideways? How are things going?
Things are going busy.
Yeah.
It's really hard to sort of paint it with a broad brush because it's been different in every state. So we just spoke about Texas. A little bit earlier in Wisconsin, actually, there had been a very restrictive voter ID law, and a federal district judge last spring had found that that law discriminated against minorities in the state. That was actually the first opinion in the country that had found a state voting law to violate a voter ID law to violate Section 2 of the Voting Rights Act, and had found that it was discriminatory again after a trial and looking at an enormous amount of evidence. That was overturned by the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals was appealed to the Supreme Court, which then stayed that opinion. Conversely, in Ohio, there had been a finding when the state tried to decrease its early voting laws that was permitted, and that was appealed to the Supreme Court, which allowed it to go forward. So we're really sort of day by day, things are changing across the country.
It's a maddening topic, not only because it's very complicated, but it's also been demonstrated time and time again that in-person voter fraud is almost a non-existent problem in this country. There aren't really any documented cases of this, and if there are, there's just a few. So why are states continually putting out laws that claim to address a problem that doesn't really exist? It's, like I said, it's maddening. Why do you think culturally or politically this situation continues to persist?
Well, you're exactly right, Lee, that these laws are really a solution looking for a problem.
Right.
There are minuscule numbers, and in fact, in both the trials in Wisconsin and Texas, there was substantial evidence saying that the number of voter fraud cases in both states were tiny, 2, 3, 7, very small numbers. But at the same time, these laws have very real impact on individual citizens and communities who really just want to exercise their most fundamental right in our country. They're really just trying to do what we expect of them as American citizens. So the laws have very real impact on communities, particularly elderly people and communities of color. And yet, the problem that they're seeking to address is virtually non-existent.
The total cost of litigating this stuff nationwide must be, I haven't seen any numbers, but I imagine it's quite high as well.
Well, I have a lot of friends who work in the voting rights community, and they haven't gotten much sleep in the last month.
I can bet. What comes next in this fight? After we get beyond the election, is anything major on the horizon?
Well, we're waiting for the Supreme Court to make a decision in Texas. There are cases that continue to sort of bubble up and boil around the country. It's really a focus on Section 2 of the Voting Rights Act. So I talked about how Shelby County found Section 4 to be unconstitutional. There's another section of the Voting Rights Act called Section 2, which allows individuals and groups to bring individual lawsuits. And that's really what's caused the Texas, the Wisconsin, the Ohio cases. Section 2 now has sort of new teeth. It's being put to work really for the first time with these laws. So really the next year or two will be a true test to see the strength of Section 2 and actually protecting the right to vote in our country. It's never been put to that test before, so it's really in the spotlight.
So going forward, Eric Holder, of course, is going to step down from running DOJ in the near future. What does his departure mean for this situation entirely?
Well, the Department of Justice certainly has, under Attorney General Holder's leadership, has been very strong on protecting the right to vote, particularly in minority communities around the country. He's done tremendous work, and his staff has done tremendous work to uphold that right. So we certainly hope that President Obama's nominee will continue that fight, because certainly there's plenty of work to do.
Wild stuff. Erika, thank you for stopping by and unpacking this for us.
All right, thanks.
That's Erika Wood from New York Law School. If you'd like to see more of the stuff they're working on here, be sure to go check them out online. I'm Lee Pacchia. See you next week.